Good morning, everybody, and welcome. It's 9:05, and it's a beautiful day in Johannesburg, South Lenasia today. Welcome, everybody, to our domestic violence webinar today. I am not alone with me. I am with Ms. Nobukanya, and thank you for joining Ms. Nobukanya. And then our presenters today is Ms. Andrisha Hickenman Dlamini and Ms. Malefa Nzamo. So I'm going to read their bio and then they can take over. So to note, you can please add your name, your organization, and your email address on the chat. Ms. Andrisha Dlamini bio reads as follows. Andrisha Dlamini is a partner in the dispute resolution practice group in Johannesburg office. Her expertise include providing general commercial advice, and she acts for the range of international and multinational companies, assisting them in navigating high-stakes litigation and developing practical strategies to manage and mitigate legal exposure. In addition to her commercial practice, Andrisha has developed significant expertise in matters relating to domestic violence. She has represented clients in court proceedings involving protection orders and frequently advises on the practical application of domestic violence legislation. Her commitment to combating gender-based violence extends beyond her legal practice. Andrisha has facilitated multiple community workshops aimed at empowering individuals with knowledge of their rights, the mechanism available under the Domestic Violence Act, and how to navigate the court process. She firmly believes that addressing the social ill of domestic violence extends far beyond the confines of a courtroom and requires collective responsibility and action. Her work reflects a deep commitment in advancing access to justice and supporting vulnerable individuals within affected communities. And then our second presenter is Malefa Mzamo. Malefa Mzamo is an associate in the Litigation and Dispute Resolution Department at First King's Johannesburg office, where she focuses on commercial litigation and advises clients on regulatory compliance and dispute resolution matters. Before joining the litigation team, Malefa works in First King's pro bono department, where she represented clients in domestic violence, children's rights, and maintenance matters. Work that continues to inspire her ongoing advocacy. She remains deeply committed to empowering women and communities affected by gender-based violence, regularly facilitating workshops and engagements aimed at strengthening awareness of domestic violence legislation and action. Ms. Enrique, welcome to take over.
Good morning, everyone. Thank you so much for that lovely introduction. It is an honor to present this morning on the Domestic Violence Act, its legislation, as well as the regulations. I am also joined, as you mentioned, by my colleague Malefa Mzamo, and we will just be sharing some of the practical tips that we've encountered when dealing with the Act, as well as representing clients in court. So without any further ado, I will share the presentation shortly. If there are any questions from the floor, can I please ask that you put it in the chat box and we will deal with it after the presentation. And if you can't hear, so if there's any connectivity issues, please alert us as soon as possible. We will actually switch our video off to ensure that we have good connectivity. The presentation is quite lengthy and it might appear to be very theoretical. So what we will do is we will, in between the legislation and the Act and the regulations, we will give some practical tips on how to navigate it. And then at the end, we will deal with any questions from the chat box so that we can actually go through the presentation in the event that we do actually cover your question throughout the presentation. So what I will do is I will switch my camera off and then I will share the presentation. And then I will kickstart the presentation. So on the agenda this morning, we will be discussing the applicable legislation. And then we'll go through what is domestic violence and why it's important to understand the different forms of domestic violence that the Act recognizes. We will then cover what is a domestic relationship and why it's important to understand this definition as provided for in the legislation. We'll then go through what is a protection order, how and where to apply for a protection order, and then we will deal with what to expect at court when lodging an application. And we'll take you through some practical tips and what we've encountered when dealing with protection orders and lodging protection orders on behalf of our clients. And then lastly, we will close the presentation with best practices. Like I mentioned, the Domestic Violence Act 116 of 1998 regulates domestic violence in South Africa. We then also have an amendment that was introduced by the Act in 2021. And then we have regulations that have also been introduced in 2022 and 2025. And really the main aim of these amendments and the regulations is really to strengthen the efforts to end gender-based violence in the country, and also to improve the protections available to complainants of domestic violence. So the Domestic Violence Amendment Act came into effect on the 14th of April 2023. And in the next slide, I will take you through really just the important amendments that have been introduced by the Amendment Act. There's quite a few amendments that have been introduced by the Amendment Act, but I won't go through each and every one of them. I think the important ones to note is that the Domestic Violence Amendment Act broadened the definition of domestic relationships, as well as included additional forms of domestic violence. We have a separate slide on this, so I won't expand too much on it now. And then the second important note to take note of is the expansion of jurisdiction. And this is really where a complainant can lodge an application for a protection order. And this has been expanded for complainants under the Amendment Act. And then something interesting that has been introduced by the Amendment Act is a domestic violence safety monitoring notice. Now, this is a notice which can be applied for concurrently with the protection order or even before a final protection order is issued. And this is usually in instances where a complainant shares a joint residence with the abuser or the respondent. Then they can actually apply for domestic violence safety monitoring notice with the court, and the notice is then submitted to the clerk of the court, and the court can then grant this notice. And really what this notice is to empower the South African Police Service to check on complainants on a regular basis. And the notice also allows SAPS to, in instances where they can't access the residence of the complainant, to actually use reasonable force to overcome any resistance when they seek to access the shared residence. We will deal with each and every single one of these amendments on separate slides. This is just a high-level overview of the important amendments that the Act has actually introduced. We will then also touch on after-hour applications and what do you do if you want to apply for a protection order and it's outside of the court hours. So I'll kickstart with what is a domestic relationship. It's very important to understand when we deal with domestic violence, to understand what is a domestic relationship. And the reason for this is really because a domestic relationship governs whether or not you actually apply for a protection order under the Domestic Violence Act, or whether you apply for a protection order in terms of the Harassment Act. So it's very important, if you're advising somebody or if you yourself are applying for a protection order, to firstly tick off this requirement to understand whether or not a person, a complainant, and the respondent are in a domestic relationship. The first would be either if they are married. This could be through any law, customary law, or religion. The second is whether the complainant and the respondent, if they are unmarried, or if they're a couple of the same or opposite sex, so if they're living or live together in a relationship in the nature of a marriage, that would also be deemed a domestic relationship under the Act. It could also be a parent or a child relationship, or someone who has had parental responsibilities. The Act also notices or recognizes this as a domestic relationship. Then instances where there are family members related either by affinity or adoption, that's also considered to be a domestic relationship. And then a couple who are engaged or dating or in a romantic or sexual relationship for any duration, the Act recognizes as a domestic relationship. And then you'll see the last bullet that we've highlighted notes people in a close relationship who share or recently shared the same residence. Now, this means a relationship between the complainant and any other person or the respondent, which the court, with regard to certain factors or criteria, can establish that there's actually a domestic relationship between these two individuals. So factors that the court would consider to see whether or not there is a close relationship is the length or the time that the relationship has existed for, the degree of intimacy between the two persons, the frequency of the contact, and also the level of dependence on each other and the commitment to each other. And this is a new consideration that has been introduced by the Amendment Act to establish whether or not people are in a close relationship and will also be deemed to be in a domestic relationship in terms of the Act. And like I mentioned, it's important to understand if there is a domestic relationship, because if the relationship does not fall into any of these categories, so marriage or people in a close relationship or a parent or a child, then it is not a domestic relationship as defined in the Domestic Violence Act. And in that case, a person can either apply for a protection order in terms of the Protection from Harassment Act, or they may rely on any other applicable legislation for the appropriate relief. So it's very important to understand what is a domestic relationship. Now that we've covered what a domestic relationship is, the second important point to be able to note is, am I being exposed to domestic violence? Now, the first part you'll see is not highlighted, and then we've got new additions at the bottom. The new additions is what has been introduced by the Amendment Act, but instances of domestic violence would be physical abuse, sexual abuse, emotional abuse, verbal, psychological, or economic abuse. Then we also have intimidation, so behavior by a respondent, which is intended to force a complainant to either do or not to do something which they have a lawful right to do. So this would be, for example, using acts or threats of physical violence to the complainant, or depriving a complainant or any other person of their freedom. So that would be under intimidation. Then harassment. You'd also see damage to property, as well as entry into the house without consent. But I'd like to just touch a bit on the economic abuse. Now, the economic abuse is a form of domestic violence that is recognized in instances where a complainant is entitled under the law to a certain requirement. So, for example, if the respondent usually pays for the mortgage bond or pays for the school fees, when you're applying for a protection order, one of the instances where a complainant might be hesitant to apply for a protection order is because they fear that the respondent would actually withhold the money that is necessary and that the respondent is responsible for. And this would be, like I said, the education expenses or paying for a mortgage bond. Now, the economic abuse is it's important to understand that this is emergency monetary relief. And this is really just compensation for losses suffered by the complainant at the time of the protection order. And it's important to realize that the court will really grant this, and if they do grant it, it will probably be just for a 2-month or 3-month basis, because you've got the maintenance court that actually deals with maintenance issues. So when you're applying for domestic violence, for protection order under the Domestic Violence Act, you do have this option to apply for the monetary relief. But it's important to understand that the court will not provide this for a very long duration of time, because you could apply for this in terms of the Maintenance Act and in the Maintenance Court, and there's a specific court that actually deals with this. But if there is any emergency monetary relief required at the time of the protection order, this is relief that you can ask for. And a lot of the times people are not aware of this specific relief that is available and that you can actually ask the court for. But when Malefa takes us through the actual form, she will also indicate where exactly you can fill this in and what you have to indicate to the court at the time. In the new additions is coercive behavior, controlling behavior. This means behavior towards a complainant that makes them dependent on or submissive to the respondent. So instances where isolating them from sources of support, or exploiting their resources or capacities for personal gain. So those are the kinds of controlling behavior that the Act also recognizes as domestic violence. Then we also have elder abuse, exposing a child to domestic violence. And this means when you're intentionally causing a child to witness an act of domestic violence or to experience the effects. So if a child is being exposed to domestic violence between two people that are in a domestic relationship, the Act actually recognizes this as a form of domestic violence. And then lastly, sexual harassment, related persons abuse, and spiritual abuse. So these are really just the different forms of domestic violence. It's not just limited to physical abuse or emotional or psychological abuse. The Act recognizes many other forms of domestic violence, and the amendments, in fact, included additional forms of domestic violence. So now that we've actually touched on what is a domestic relationship, so that now tells you whether or not you can actually apply for a protection order in terms of the Domestic Violence Act, and what forms of domestic violence is recognized by the Act, we're going to go into what is a protection order. Now, this is a court order that's issued by the court, the magistrate, and it lists various acts that the respondent, the abuser, is prohibited from committing in relation to the complainant. So like I mentioned earlier on, there's various forms of domestic violence. You can tick off every single act of domestic violence if that is what you are exposed to. You don't have to limit it just to physical abuse or psychological abuse. If there are other forms or various other acts of domestic violence, you want to make sure that you tick the relevant box on the application form, and that you bring that to the attention of the magistrate, so that that act can be, that the respondent can be prohibited from actually committing that specific act. So it's quite important. And the reason why I'm emphasizing this is because if you have a protection order that doesn't prohibit you from that specific act, you can't enforce it. So it's very important to understand the different forms of domestic violence that you are exposed to, or if you're assisting a client, that you obviously make sure that you cover the various acts. And then the purpose of the protection order is really to prevent the respondent or the abuser from further acts of domestic violence being committed against the complainant. We will go in through the details of this a bit later. Then applying for protection order. So who can apply for a protection order? Firstly, it's any person in a domestic relationship. It's any related person subjected to the related person abuse, any child subjected to domestic violence, and this would be a social worker that can do it on behalf of the child, a neighbor, and then any person with a material interest in the well-being of a complainant. So these are people that would be able to approach the court and apply for a protection order. Then how do you apply? You can apply in person, and I will go through which court has jurisdiction shortly. And then also the Act of Amendments make provision for applying for protection order electronically by email. But I have not encountered this. I have not seen the rollout of this in our courts, especially in the Johannesburg area. Myself and Malefa have been doing most of our applications, or all of our applications, in person, because this has not been rolled out by our courts as yet. And then the last point is there is no need to give notice to the respondent. So the application, when you're applying for protection order, in law we call it is brought on an ex parte basis. And this means that you can apply for a protection order by yourself. And the reason why you don't want to notify the abuser or the respondent that you're actually applying for a protection order is because it can actually, in some instances, aggravate the respondent or the abuser. And in that instance, when you do apply for a protection order and you notify them, then you are not even protected as yet. So it's really an application, if you're exposed to domestic violence, that you approach the nearest court and you bring that application on your own. It is only once the court has considered the application and either issues a notice to show cause, an interim order, that the application is then brought to the attention of the respondent or the abuser, but there is no need to give notice to the respondent. And then where to apply for protection order. You'll see on the slide that we have highlighted in red some important additions, and these are really just additional parts that have been included by the Amendment Act. So we have here any magistrate court within the area in which the complainant permanently or temporarily lives, works, or studies. and then where the respondent permanently or temporarily lives or works or studies. And the reason why we've highlighted some of these is because in the past, before the amendment, you could only apply for a protection order where you resided. And because the amendments were introduced to give complainants access to courts, easier relief to instances of domestic violence, it now says that you can apply for a protection order at any magistrate's court, as long as it's a magistrate's court and it's the closest to where you live or you study or you permanently live or temporarily live. And so, for example, if you are a student at UJ and you're exposed to domestic violence, you can apply for a protection order at the nearest magistrate's court to the place where you study. And you don't have to apply for it where you reside, which was the position in the past. And most of the times when you are assisting a client with applying for a protection order and you have to then bring that protection order where the person resides or temporarily lives, that means the complainant actually has to take a day off leave at work to actually bring the application. But with the amendments, it's actually tried to make it more accessible for complainants to approach any magistrate's court, either where they live or reside or even work or study. And I think this is quite important because it actually does assist with actually accessing the nearest court. So I'm going to hand over to my colleague now, Malefa, who will take us through how do you apply for a protection order.
Right. Good morning, everyone. As my colleague mentioned, I am Malefa Mzamo, and I'll just be looking at more of the practical aspect in terms of, protection orders and how you go about applying for one. So Andrisha has obviously now gone through the jurisdiction and which magistrate's court one should approach if you have encountered domestic violence or if you are encountering it. So it's very important to know that the form that is used at the domestic violence court is what we call a Form 6. Now, this is the form that you will use to apply for a protection order. This form is very important, even in instances where clients or a complainant is represented. You still use this form as an attorney, you use it as a social worker. So we thought it would be best for us to actually share this form with you so that we can go through, just to give tips on how to fill it in and what is important about this form, seeing that this will form the basis essentially of your application. And it is the form that will determine whether you do get a protection order or not. And it will also determine what the complainant will then be protected from. Okay, so now we'll just share the form and I can go through it with you section by section. So you will note that this is the Form 6 that I just spoke about, and this is how it looks like. Before we go into it, just on a practical aspect, you can find this form on the internet. On when you search for it, you can find it. You can also find this form at court. So if a complainant is represented, in our instances, most of the time we do fill it in beforehand. Then by the time you go to court, the form is completed. So if you do have experience with this form, it is best to assist a complainant maybe as a social worker to fill it in. But if the complainant is going on their own, we would suggest that they rather get the form from court, firstly to ensure that it is the correct form, and secondly, to then be in the vicinity of a clerk of the court to assist them how to fill in this form correctly, as I previously mentioned the importance of the form. Right, so just to start, you'll see that the first section, which is Part A, that will be the information of the applicant or the complainant, which is the person that's being exposed to domestic violence. That will just be their surname and their full name, which is obviously important. Then the second part would be particulars of a person making the application on behalf of the complainant. Now, as Andrisha mentioned beforehand, when she dealt with who can apply for protection order, rather, you can apply on behalf of a person, and this would mostly be maybe where a person is a minor or the person is mentally incapacitated, or maybe if it's an elder person that cannot do this for themselves. So then this part would also be important, where you would write your details, your surname and your full names, and then you'll see that the form provides, blocks there where you can tick in what capacity you are essentially making this application for the person. So as a social worker, you'll tick there that as a social worker, as a police, member or family member. And if it obviously does not fall within these blocks that are provided, there is that last block that says other, and then you specify maybe this will be in an instance where I'm a neighbor and I am aware that a child is being exposed to domestic violence, whether it is being inflicted on them. And as you know, with the new amendment, also just exposing a child to domestic violence is also now deemed domestic violence. So you can put that in. So that's also important. Then you have the third part, which I would also say is very, very, very important, because this is essentially what will determine whether you are in the correct court or not, and whether you have used the correct form. And this is what Andrisha was discussing earlier in respect of a relationship. What relationship do you have with the respondent as the complainant? Is this person your boyfriend, your ex-husband? And this form is also great in that at least it gives you those options, in that now you can tick where with the applicable relationship. That's obviously very important. And then now once we have, you'll see that it does really give a lot of options. So so as you move on, then you will fill in the names of the respondent. Now, obviously, also very important, because this will determine also then where this needs to be served, and the court needs to know who the complainant is. So you will see that the form is also great in that it guides you. Fill in the surname, the full names, the ID number of the person, or the estimated age if you're not sure, their home address if known, work address. So an address will be important, because this is also the address that will be used when you go serve the protection order. So you fill that in, the cell phone number, contact details. If they have any social media, you can also fill that in. So you will see that the purpose of this section is to really give as much information as possible about the respondent, to ensure that it is easier to get a hold of them, whether it is from the complainant side or from the court side. Occupation, where they work or go to school, so that's important. Now here is where we now get into the gist of the form, which you will now essentially lay down what the history of the abuse is. I always say, or we always say, that this part where it says history of abuse, e.g., dates, time periods, places, types, this is the best. Basically, this is the best thing that you can use to help a complainant, or for the complainant themselves, to fill in this form and to know which information about the abuse is important. So you almost want to tick as you fill in this section. You want to fill in the date. If they can remember, or normally would say in and around May of 2024 or 2025, then you tick that you have dates or time period. Place, you would then say in and around this time at Sandton City, that's, you tick the place. My boyfriend and I, for instance, were walking in the mall and they hit me, then that's how you just continue. As you're filling it in, you kind of try to tick these lists that they give you. What instrument, you will say that my boyfriend stabbed me with a knife, and you click the instrument, the weapons that were used. Then you also go into injuries. I, hurt this part of my body. And then you can also say that whether you went for medical treatment or not. So this is essentially the best way, because when you think about it, when a magistrate is considering this form, you're giving them, you essentially want to fill it in such a way that they don't now wonder, where did this happen? When did it happen? How was the abuse inflicted? What was used? So you want to make sure that with this part, you tick all those questions that the magistrate might have. And this will be more about the history. So you want to go back into essentially when you would essentially say here that, you have been abused by the certain person from, it's been coming for years, so you want to focus more on the history, because the next section, we will then deal with the most recent abuse. So again, you'll see this section will also guide you, date, where it happened, what happened. You will then state the details of the abuse of that specific incident that happened on that date that you would have provided, what injuries. You would also go into the injuries that were sustained. Once you have gotten into the injuries there, then you will say whether any medical or psychological treatment were received. There you want to put in, if it's true, you want to put in the place, who's the doctor. Then you want to say what was the harm or the damage. Then you give details there. Again, the place that happened. So again, this form is to make sure that you give as much information as possible. If you have any medical certificates that you received, that would be very important. That will obviously help in terms of, evidence and whether you have a prima facie case. And these are the things that we will then attach, which we will show later as we go. Then any other information regarding the acts of domestic violence that you think the court should know of. So sometimes you find that the person that is abusing you, it may be that in some instances they make use of other people to inflict abuse or any sort of pain on you. So there you can write that maybe the respondent only sends his sister or his mother or friends to come and harass me or stalk me. Those are important. Or maybe you can mention there that the respondent has a firearm, or any information that you could not include above. Here you will include it. And then again, urgency. Now, this would also be very important in instances where you share residence with someone, for instance. Why is this application urgent? You mentioned there why it's urgent. Why is it that you need it today? What's the reasons for that? You'll then state that this person, has threatened me. These are the messages that they've sent. They have a firearm. We stay in the same residence. Those are the reasons then that you will put in this section to state why this application is urgent. And this is also important because if you do prove urgency, that will also help in terms of whether the court or the magistrate will then grant the interim protection order, or whether they think they should just provide a notice to show cause. So that's an important part. And then you'll see here, you're still staying in the same place as the respondent. Are there firearms or any other weapons in the house? Give details. Does the respondent carry or have access to firearm or work purpose for work purpose activities? For instance, if maybe the respondent is a police officer and they obviously are provided with firearms, which they are allowed to take home. If that's the case in this instance, you may include it in this section. And what you can do also is to maybe ask from the court that the person must then leave their firearm at work before they come home. Those are things that basically are provided for when you fill in this form. Okay, then do you fear for your life? So this would also go to the urgency and also the severity of the domestic violence. This is also very important. Does the respondent make use of drugs or any other substances such as alcohol abuse? And this would also be important because it is obviously known that some people do get violent when they are under the influence of either drugs or alcohol. Then I would say, I've said that every part of the form is important, but I think I'd almost want to say that this is probably one of the most important parts of this form, because this is what will then determine what you are protected from as the complainant. Very important. Now you will see that this section has a lot of blocks, and what we've sometimes experienced is that people are quite shy to tick a lot of boxes. You tick the most boxes, obviously, if it is the truth. If the complainant is subjected to physical abuse, you tick it. Sexual, economic abuse, intimidation, harassment, controlling, threatening behavior. If all these things that are listed here fall within the abuse that the complainant is being subjected to, you need to tick it. As you tick, sometimes you get a bit shy and you think, oh, this is too much. But essentially, as I mentioned, this is what will determine what the complainant is protected from. So don't be shy here. As long as it's the truth, you tick it. As I mentioned here, you'll see B says not to get help of another person to commit any acts of domestic violence. I would also say that's an important one because that's what people normally do. They'll send people, use other people to inflict some sort of abuse on the complainant. So you take that if that's important. Not to enter the shared residence situated at. Now, in terms of a shared residence, sometimes it is quite difficult to obviously just say, hey, this person is abusing me, therefore they cannot stay here anymore. You know, you get instances where people are married where they are both entitled to stay there. And we obviously know that in terms of law, there are other things such as evictions. So here, what we have experienced sometimes is that maybe the court would say that, you know, there's a certain portion of the house, like essentially share the house and say, this is what you this is the section of your house to use, and this is the section, and obviously there will be communal sections that you use. So it is a bit difficult sometimes when you do stay with someone, but it is not impossible for the court to make a plan in that regard. So also enter the complainant's workplace, a place of study, not to prevent the complainant or any child who ordinarily lives or lived in the shared residence from entering or remaining. So those things are also important. We had a matter where the client that we were assisting, essentially the husband had locked her out of the house and she could not stay essentially in the house with her children. And you'll see there G, that is one of basically the prayers that we had asked for, that the complainant is not to be prevented to enter into the shared residence. And that's why I mentioned earlier that sometimes it is a bit difficult to ask the court to kick someone out of their shared residence. Okay, so those are essentially what you can then ask for if there's any electronic. So as you know, we live in a world where, you know, there's a lot of devices that we use, social media. So sometimes the threats are coming maybe from pictures that have been sent, videos, or communication. So you can also ask that they do not disclose this or make it available to anyone on social media. All right, then as we move on, the court may also then order that, as I mentioned earlier, that you can seize weapons, and you can also ask the court to basically help you to go collect your belongings if it's in the possession of the respondent. Then there's also the respondent is to pay the following interim rent or mortgage payments until the return date. The respondent is to pay the following interim maintenance until the return date. Now, as Andrisha mentioned, we do have a specific court, which is the maintenance court, and they are the ones that essentially deal with maintenance matters. Apologies. So if you are experiencing economic abuse, this is now where you can ask for that emergency monetary relief. In this instance, the court does not really go into much detail as they would as the maintenance court. If you can prove to the court, and maybe if you have documentation to show that, listen, this person does not provide us with any food, we're hungry, there is no electricity. In that instance, the court can then also provide that economic, or essentially that relief, that monetary relief. But it would also not be a final, even when the court provides you with a final order, the court will not provide you with the emergency monetary relief and included in the final order, because that is then an aspect that is left for the maintenance court to deal with and to ventilate that whole thing properly. Okay, so also here, there's also contact. And with the contact, it actually goes the same with the maintenance one. There is a children's court that is obviously assigned to deal with matters that has to do with the best interest of the children. But where children are being affected or they contact due to the abuse, this is something that one can also ask from the court. But in terms of a final order regarding parental rights and responsibilities contact, that will also be something that is thoroughly ventilated by the children's court, because that is the court that then will have jurisdiction in that regard. And then when you just go down, you'll see that then we have personal property. This will happen then maybe if the complainant has maybe gone to seek shelter because of the abuse and they just left and a lot of their belongings are still where the respondent stays, you can then ask the court to assist you to get back your personal property, such as clothes, shoes, medication, children's items, jewelry, household pets, cosmetics, documents, passport, all those things. And this is where you would list them. Property description, you would say your identity document, grounds on which property is considered to be personal property. It is obviously your identity document. And then there's also address where the property is kept, and then that's where you will put in the address of the respondent to essentially receive your personal things. Then I'm likely to report a breach of the protection order, and then the police station is also important. That would be the nearest police station. Here we also have, as I mentioned earlier, documents such as medical certificates, pictures, photos. Those are important things, and if you do have them, it's always best to already include them in this document. Don't wait to want to hand it up in court, because remember what I said, sometimes you find a magistrate that only considers whether you get whether you get an interim order based on just the papers. So the more you give, the better it is for the complainant. So don't keep these documents for later thinking, yeah, when you get to court, it's going to be a show and you're going to hand it up. No, you attach it here already. WhatsApp messages, emails, if there are threats, cyberbullying, if there's something happening on social media, someone keeps on posting about you, medical certificates, those things are very important to then include here. Then here it would just be where you sign, and then you will see that there's a form 6A, and this is just essentially where the particulars of the complainant. So you'll remember that the first part of the form, as the complainant, you just write your surname and your name. There's no number, nothing. You just write your name and your surname. And then here, this form, you'll see that it's only for office use. This is not going to be served on the respondent. And this is essentially where you, as the complainant, would fill in all your details. Your ID number, full names, where you work, where you study, all of those. And this is kept in the court file. And this is not served on the respondent to also ensure the complainant's safety. In some instances, the respondent may not know where you work or where you study, so you don't want to give them that information through this form. And then it would also be the same then if it's particulars of a person making the application on behalf of the victim, as mentioned, a social worker, a neighbor. So obviously if you are acting in that capacity, you don't want the respondent to have that information. Then you can also indicate on the form whether written consent of victim has been obtained. And then you'll see the written consent in some instances is not necessary if the victim is a child, a person with mental disability, unconscious. Yeah. Then here you can also indicate the persons that have been affected by domestic violence. So if maybe you are living with your nephew or niece, you can put their names there, the age, and what the relationship is to the complainant. And then you can also then indicate how are they affected. And this is also important to note. It's not, don't regard it as a section that's not important, because these are also the things that will add on to whether a protection order is indeed necessary or not. And then you also just give further information about these people, if they have any disabilities or not. And then the name and the contact details of the person who have witnessed the incidents. And now this is also as important as essentially documents. If you know that your neighbor is always essentially witnessing the abuse from, the abuser, it's important that you put their names there so that in the event that you do go to court, that they can come and testify. And that will obviously help in terms of your case and to get that final protection order. So that is essentially the form. It is quite lengthy, but it is very important to fill it in properly and to make sure that it is done thoroughly, right? So now that this form would have been done, what you will then do is, if you are at court and the form is done, you will take this form to the clerk of the court, and you inform them that this is this is an application that you intend to lodge, and what the clerk of the court will do is then take that application form, they open a file for you, and they allocate a case number to the matter. And then the clerk court will also then inform the complainant of the specific process that the court will follow. What normally happens is, on that day that you go and issue this application, three things may happen, and this is also dependent on the court that you are in. So in some instances, the complainant or the complainant's legal representative may be asked to appear on the day to argue why the court should grant an interim protection order immediately. So you will remember that on that day, as Andrisha mentioned, on the day that you issue it, it's ex parte, the respondent is not there. So now obviously what you want is an interim protection order. Some courts, what they do is that the complainant may be asked, or even the legal representatives, as we have experienced, may be asked to wait at court while the magistrate then considers the papers, which would be this Form 6, and any supporting documents if there are, whether an interim order should be granted or whether just a notice to show cause should be issued. Again, it takes us back to the importance of the form, because if you are not given an opportunity to argue this or to appear before the magistrate, the only thing that will be considered would be the papers. And then we've also experienced in a different court where we are asked to return on a different day to obtain the magistrate decision pertaining to whether an interim order is granted or whether it's a notice to show cause. So those three things can happen. It really does depend on the court that you are in. Now, once an interim order has been granted, the clerk of the court should furnish you or the complainant with the interim order. And if the interim order has been granted, what needs to happen is that it needs to be served on the respondent. Now, this is incredibly important because if this document is not served properly on the respondent, or if they did not receive it, then it's not in effect. They need to be aware and they need to know what it is they are not allowed to do, so that if they do contravene it, then you do have a leg to stand on to say, but they have this and they have contravened the protection order. So it's very important. Service is incredibly important. And what's also important is that obviously when you are provided or granted an interim order, a return date will also be included there. So you need to ensure that this interim protection order is served at least 10 days before the return date. You don't want to go back to court and your matter to be postponed or struck off the roll because of technical points like this. So in a case where you would have served this interim protection order 5 days before and the respondent does not come to court, it will be deemed as non-service, that it was not properly served. So those are essentially the consequences of not serving this document correctly and within the prescribed days. So in the instance where the court decides to issue a notice to show cause instead, the notice will also have a date and it will also have to be served on the respondent. Now, you still have the case, you still have a matter. It's just in that instance, the court, there was no prima facie evidence for the court essentially in that moment to grant the interim order, but obviously you will come back on the return date and then more of the evidence will be considered. So then there's obviously the return date, as I've mentioned. Now with the return date, this is the date that the court would have granted on the interim protection order or on the notice to show cause. If both parties are present, the court considers evidence from both parties and make a decision whether to make the interim order final or to extend the interim order or dismiss the case. Now, obviously, this is just very high level, just how it works. And then, and when both parties are present, a very important thing also is that the court will explain their rights to legal representatives. So that may be another reason why a matter may be postponed, to just be aware of that. If only the complainant appears, the court will proceed to hear the matter and consider the facts. If it was properly served, that if the proper service was affected, then the court may grant a final protection order against the respondent by default or dismiss the case. So this is also important. Just because the respondent is not there, it does not mean that you automatically get the protection order. The court still needs to consider the facts, the application, what's before the court, and then make a decision in that regard. If both parties fail to appear, the matter will be struck from the court roll. And if only the respondent appears, the matter may also be struck from the roll. Just a practical thing is if the complainant cannot make it to court, what we've also seen in practice is that they just keep quiet or they don't go. But what we've also seen is that sometimes the complainant sends someone, maybe their sister or the mother, to say she can't come because she couldn't get leave from work, or they are sick, and then maybe you send them with a medical certificate. So as a complainant or as a social worker that's advising a complainant, it's very important for you to let them know that once they miss a court date, they will have to start from scratch in most instances. Okay. Now, obviously, as we mentioned earlier, service is very important. And when you're serving, you can either use the sheriff or the police. Now, obviously, with the sheriff, you need to confirm the jurisdiction. What we normally do is we'll call the sheriff's office, give them the address where we want to serve, and then ask whether they have jurisdiction. Now, obviously, with the sheriff, there are costs that are involved. And when you ask for urgent service, it's even more costly. But great news is that the police can also serve, and it tends to be free and actually quicker. Practically, what we would do sometimes, especially in a matter where the interim order needs to be served as a matter of urgency, after we've gotten it, would go with the client to the police and get in the van with the police and go serve it with the respondent. And then obviously the police need to sign. The police would have the respondent sign. Now, obviously, there will be instances where people normally don't want to sign anything. So in the instance where the respondent refuses, because the police officer is also deemed to be an official of the court, they would make a note there or write that this was served on this day at this time. However, the respondent refused to sign, and that would still be deemed as correct service, and the interim protection order or whatever it is that is being served will be deemed to be in effect. Now, I'm almost done with my portion. So now we have two types of protection orders, as I've been mentioning, the interim protection order and the final one. With the interim protection order, as I mentioned, this is one that you would get as soon as reasonably possible on the day that you issue this application, the Form 6. And it must be evidence that the respondent is committing or has committed these acts of violence and that the complainant is suffering. So it would be, again, like I mentioned earlier, prima facie, if the magistrate is convinced on the papers that the complainant is experiencing or suffering any harm. As I mentioned, the interim order will be served on the respondent, and the interim order will include a return date. And then we have the final protection order. This is now on the return date or on the day that the court has now heard everyone's side of the story, and the court has now made its final decision. It will either, and if the court's final decision is a final protection order, this will also then be granted, and this will also have to be served on the respondent, especially in an instance where the respondent may not be present at court. It is very important that you ensure that this final order is served. What we normally say is with the return of service, if the respondent was not at court and you served the final order on the respondent, it's important to ensure that that return of service or the proof of service that you got from either the sheriff or the police, take it back to court and let it be placed in the court file, especially in an instance where if you lose it as the complainant, at least you know that you do have it in the court file. And should the respondent contravene any order, one of the things that you're always asked is the proof of service, that they know that this person was aware of it. And if you don't have that, that may cause issues. So very important to take back that proof of service of the final order back to court. So that's important. So Andrisha will now, just one last thing. There's also then the failure to comply with a protection order. It is a criminal offense. So in most cases, people always say, yeah, but paper can't protect you. You go there, they're still going to abuse you, which is true. Yes, a paper cannot protect a person, but you are in a far worse position if you are being abused and you do not have an order, because it's then difficult to arrest that person. But once you have your protection order and that person, they contravene it, becomes an immediate criminal offense and they may be arrested. A first time conviction, it may be then a fine or imprisonment up to 5 years, and a subsequent conviction, a fine or imprisonment up to 10 years. Okay. So that's it from my side in terms of my section. I'll just then hand over to Andrisha just to finalize the best practices, and then we'll take questions after.
Thank you, Malefa. So now that we've gone through what is domestic violence, and Malefa has taken us through great detail on the form, how do you serve the protection order, and the difference between an interim and a final protection order, just a few tips from our side and what we've encountered in practice is safety is a top priority. Most of the times when we do bring an application for protection order, it can aggravate the perpetrator. So in a case where our client would advise us and say, I don't feel safe bringing this application while I'm in the same shared residence with the respondent, we would try and place that complainant in a shelter before proceeding with the application, or we'll try and find out if there's a family member that they can reside with, that they feel safe with, before lodging the application. And really the reason for this is to ensure that when you do bring the application, as mentioned earlier on, it is brought on an ex parte basis. So when you do bring the application, you want to ensure that when the police or the sheriff serves the application or the interim protection order or the notice to show cause on the respondent, that the complainant is in a place of safety. And then the second point would be keep out of dangerous situations. And really what this is do not attempt to go to the respondent's place of residence to serve any documentation on them. So whether it's the interim protection order or the notice to show cause, like Malefa mentioned, rather go to the police station so that they can assist you with service of the protection order. Or if you have an attorney assisting you, they would most probably ask a sheriff to effect service of the notice to show cause or the interim protection order on the respondent. But it's so important to keep out of dangerous situations. You don't want to be in a situation where you're applying for protection order, and once it's served, then the respondent is then aggravated by the entire application. And then proof of service is very important. As mentioned, if you can't satisfy the test that service has been effected on the respondent, the court will not hear the matter. So they will either throw the matter out, postpone it to a later date. So it's so important to have proof of service, get a copy of it from the police station, or get proof of service from the sheriff if service has been effected, to ensure that the matter is heard and not postponed to a later date. We're just going to go through some frequently asked questions. We've got some frequently asked questions, just 3 of them, and then we'll have a look at the chat to see if there's any comments or questions from the floor. So the first is, how do you enforce a protection order? So when the court issues the protection order, they will also issue a warrant of arrest. As I mentioned earlier on, the amendment introduced this. In the past, you would have to apply for a warrant of arrest. Now, if you're applying for a protection order and an interim order is granted, the court will simultaneously issue you with a warrant of arrest. But the execution of that warrant of arrest is suspended up until the respondent contravenes the terms and the conditions of the protection order. So once you have a protection order, make sure, if you're unrepresented, that the court issues you with a warrant of arrest, because once the respondent contravenes it, the only thing you need to do is go to the police station, inform them of the interim protection order. They'll ask you for the warrant of arrest. And what the police can then do is they will then be authorized to arrest the respondent. And then they can then obviously ensure that the respondent complies with the protection order. So this is very important. Most of the times we'll find that a client has a interim protection order, but they don't have a warrant of arrest. And then we have to approach the court to get that warrant of arrest. So it's so important that if you're unrepresented or if you're assisting somebody, to get the warrant of arrest with the protection order, so that once there has been a contravention, you can then immediately ask the police to enforce the protection order. So enforcement of a protection order is valid until it is set aside by a court or until the complainant withdraws the application for the protection order. So if the respondent continues with the act of domestic violence after the protection order is served, then, like I mentioned, you'd go to the nearest police station, inform the police of the act of domestic violence, The police will often ask the complainant to depose to an affidavit, setting out exactly what has happened, and then a criminal charge will be laid for violating the protection order. Like Malefa mentioned, violating, contravening a protection order is a criminal offense. And so once a protection order has been breached, it becomes a criminal court process. And the police can also arrest the respondent. How long does a protection order remain valid for? An interim protection order remains valid until it is either replaced by a final protection order or set aside by a court. So remember, if you approach the court on an ex parte basis, you're bringing the application for the first time. The court will then either consider the application and at that moment, without hearing the evidence from the respondent, grant an interim protection order and then also issue you with a return date. And then on the return date, the court will hear both sides, both from the complainant and the respondent, and the court can then decide to convert that interim protection order to a final protection order, or the court will decide to set aside that court order because there was no basis for it. So when you do apply for an interim protection order and you go back to court on the return date and the matter is not heard, make sure that the interim protection order is extended, because usually it will only be valid for a certain period of time. So if you apply for the protection order on the 8th of April or the 9th of April and the return date is on the 20th of April, but on that return date the matter is not heard due to the fact that the complainant is unable to get leave from work, whatever the case might be, ensure that you ask for that interim protection order to be extended until the next return date. Because if it is not extended, it lapses. And that's quite important, that if you're advising a client or if somebody or if you applying for protection order yourself, that date is extended to ensure protection while you wait for the return date for final order to be granted. A final protection order remains valid and enforced indefinitely or until it is set aside by a court. Now, what can happen is either party, the complainant or the respondent, may apply to request the court to set aside a protection order, or even in some instances to vary the terms of a protection order. But this is a very high threshold, and the court would only grant this order if they're satisfied that the other party has been served with the application to vary or set aside protection order, or if there has been a material change in the circumstances since the protection order was granted. But like I've mentioned, it's a very high threshold. The court really needs to understand and be convinced that the complainant is not doing this under duress and that there's good cause for the variation or the setting aside of the protection order. And then lastly, in the beginning of the presentation, I made mention of the Domestic Violence Safety Monitoring Notice. Now, this notice was introduced by the Amendment Act, and it really is just a notice where if a complainant shares a residence with the respondent and reasonably suspects that the respondent poses a threat to their personal safety, they can then apply for this Domestic Violence Safety Monitoring Notice at the time when they actually make the application. So after considering the application, the court may then issue this notice, directing the police to either contact the complainant privately or on a WhatsApp or whatever electronic platform, or alternatively to visit a complainant at their residence at regular intervals. And as I mentioned earlier on as well, if they can't access the residence of the complainant, they can actually use reasonable force to do so. Now, this monitoring notice is something that we have not seen personally being rolled out yet, but it is something that the Amendment Act has introduced. And the monitoring of this by the police means that they also have to complete a report detailing every contact made with the complainant and the outcome of that monitoring of the complainant's safety. And that report is then annexed to the domestic violence application. So this is one of the measures that a complainant is offered in terms of the amendments that have been introduced into the Act. But like I mentioned, we have not seen it being rolled out in practice as yet. And this is one of the reasons why we often advise our clients, or we try and relocate our clients to a place, to a shelter if it is possible, and depending on where they are located. Alternatively, we will ask our clients to actually move in with a family member or a brother or somebody that they ultimately feel safe with, because this notice has not yet been rolled out. So I will stop sharing, and then I think what we can do is we can just have a look at the chat and just see if there are any questions in the chat from anybody. So I'm just going to stop sharing, and then I just want to open up the chat, and then between myself and Malefa, we will just jump in. I see there's quite a few comments in the chat, so please excuse us if we do miss a few. We will just try and go through it and then just see that we don't miss any of the comments. I don't know, Malefa, if you've picked up on a few as yet.
Yes.
Otherwise, okay, perfect.
I think what we can do is if we can go through it, but I think what would also be best is maybe if the people also ask, the question, because now a lot of people have just greeted, morning, and left their details. So the questions are kind of lost in
the chat.
But from the questions that I have seen, and that maybe that Andrisha and I can do so long, if we've missed it, then I think this is where we will then ask the people to maybe ask the question themselves. So I saw a question of someone asking that if their child who's married is maybe being exposed to abuse, can they maybe bring that protection order on their behalf? And I think in this instance, if they're married, we're assuming that they are a major, and if they're not mentally disabled, unfortunately, one would either have to get their consent, and you'll see that on the form, on page 11 of the form 6, where there is a box there that asks that if you have obtained the consent of the person that you're bringing the application on their behalf, and the only time then that you would not require that signature would be if it's a minor or if it's a mentally disabled person. But if you're trying to bring an application on behalf of a major who can do it themselves, you will have to obtain consent, signed consent, and attach it to that application. If they do not provide you with that consent, unfortunately, you cannot do that on their behalf. Yeah.
Perfect. Thanks, Malefa. I see the chat is jumping a bit, but I'm going to go to the next question. It says, what happens if the complainant doesn't want to sign the consent form when offered assistance? So I think what happens if the complainant doesn't want to sign, sorry, am I reading that correctly? Yeah. What happens if the complainant doesn't want to sign the consent form when offered assistance? So like Malefa mentioned, if it is a major, you would have to get consent. If it is not a major, then unfortunately you can't bring the application on behalf of somebody if they do not want to consent to it, provided that they obviously are not mentally incapacitated or they're not a minor. That is really just how the Act works, and it's also just it makes provision for people that can't bring the application on their own if they are minor or if they are mentally incapacitated. And what the courts would then deem or see it to be deemed as, if the person doesn't want to consent, is that they just do not want to bring the application and they cannot be forced to apply for protection order if they are mentally able to do so and they do not want to do so on their own because they are a major. I also saw another question on the economic abuse and how can you apply for the economic abuse. So on the form 6 that Malefa took us through, and I don't know if I can just quickly, I don't know if it will change on the shared screen. I'm just going to see if I can't share it. But essentially on the form itself, it actually provides you with the section where you can actually complete it and just show. So I'm just going to quickly see if I just change. So there's a section where it exactly says the economic abuse that the respondent is actually inflicting or prohibiting you from. And like Malefa mentioned, it is actually something that is only an interim relief because you have a maintenance court. So there's a section on the form that actually says, I think I've gone a bit too down. I just want to take you to that specific section. Yeah. So under 7, it talks about additional conditions, and it says the respondent is to pay the following interim rent or mortgage payments until the return date. So the economic abuse that the Domestic Violence Act talks about is really instances where the respondent would prohibit or would fail to pay certain necessities that the complainant is entitled to. And when I say necessities, it's really like rent, mortgage payments, the children's school fees. It can't be things that are not a necessity and that you would like the respondent to pay. For example, if the respondent pays monthly for gives you a spending money or something like that. That's not a necessity, and the DV court will not consider it because it's not a maintenance court. They'll only grant interim relief for a month or 2 months to provide the complainant with an opportunity to actually approach the maintenance court for a maintenance order to ensure that the respondent actually complies with the financial obligations that they have. And because that court is able to actually investigate the financial position of the respondent and consider bank statements, etc., that is why the court, the domestic violence court, will not consider those kind of considerations when they're actually granting the economic relief. It's really monetary emergency economic relief, and it's only instances such as rent or mortgage payments that is a necessity that the complainant requires for a very short period of time, and so that there's no confusion between maintenance between the maintenance court and the domestic violence court. But like we said, domestic violence takes various forms, and in some instances it could be where the respondent is prohibiting or failing to pay certain necessities that the complainant is entitled to.
I think there's also another question that I saw. I think it was 2 or so questions, but it was more on what happens in the instance where you experience cyberbullying and the person is maybe using a ghost social media account, or you just don't know who the person is. I think that's obviously a good question. You can obviously still approach the court in that instance, but before the court can even grant an order, in most cases, they will have to take some sort of investigative route where maybe if you come and say these threats are coming from WhatsApp or Facebook, maybe they can subpoena the officers, Facebook, WhatsApp, and see if they can get and maybe trace that information. But I think in this instance, the best thing that one would do is maybe open a police case rather under the Cyber Crimes Act. And there, I think the police are then in a better position to then deal with this matter under the Cyber Crimes Act. And I think once you do know who your perpetrator is, then it would even be best to then approach the court for protection order in that instance.
There's another question that says, can the respondent provide the magistrate with an opposing statement of the protection order or harassment order? And would you recommend for the applicant to get a lawyer? And is it normal to appear twice or more? Sorry, it's just jumped again. But I think the last part of that question was, is it normal to apply or to appear more than twice in the DV court? So just on the first one, it is the respondent is entitled to put forward an opposing statement, and that's really the reason why the court issues a return date, because the court will consider the evidence. It's on a balance of probability. So the court would consider the complainant's evidence saying that I have been abused. These were the different acts of domestic violence. This is the history of domestic violence. And then the court would then either decide to grant the interim order or the notice to show cause. Then on the return date, and that's why it's so important to actually serve that document, irrespective of what it is, on the respondent, so that the respondent can come to court. And the purpose for that is for the court to hear the version of the respondent, so that each party has the court's ear. So that's really what it is. The respondent is more than entitled to put their version before the court. The court will then consider both versions, that of the complainant and the respondent, and then make a call on whether there is actually a form of domestic violence. And like Malefa mentioned, it's so important to have a very substantive application when you go to court. That is why we complete that form beforehand. We attach all the evidence. We look to ensure that there's no loopholes in the application form. And it really sets out, that form is a story that you're telling the court, because in some instances, the court would actually just consider the form to grant that order and not even hear both parties. But the respondent is entitled to put their version before the court, and based on that version, the court can then make a decision. There is a possibility that you can attend court on 2, 3, even 4 occasions if the respondent is unable to attend but has notified the court. So, for example, unable to get leave or medical reasons, unable to attend court. Most instances, the court would also pick up on a pattern of abuse. So if it is the case that the matter has been postponed and the complainant is being prejudiced by it, that is important to bring it then to the attention of the court. And what is the prejudice that you're actually suffering? So do you have to take leave all the time to appear in court? Is it a costly thing? But also, if there is an act of domestic violence, the court will always ensure that the interim protection order is extended to ensure that you still have protection even if the matter is postponed. But the reason for the postponement has to be substantive. It needs to be medical or something to that effect. Usually, as legal representatives, if a matter is postponed more than 2 occasions, we will raise the prejudice in court with the magistrate and request that the matter be finalized because of the severe consequences of the prejudice because of the postponements on a regular basis. So usually it is, especially in protection orders, it's rare that we encounter that it's postponed for more than 2 occasions. But if it is, there has to be a very substantive basis for it.
Yeah, and then I saw a question that asked what happens if the respondent cannot be located or refused to sign. I think the refusal of the signature, I just touched on a bit earlier to say that, remember, with the sheriffs and the police, they are essentially court officials. They are essentially court officials, and if you do not want to sign, then what would then happen is that the sheriff would indicate that in their return of service to say that this document was served on this person at this time, and they refuse to sign. But with the police one, normally they need that form that is signed. But if the respondent still does not want to sign, they do the same as the sheriff to indicate their refusal to sign, and this would not then render a non-service or defective service rather. And then in an instance where the respondent is known but cannot be located, in our law, we have alternative ways to serve, and this is something that you have to bring an application to the court and ask the court for what we call substituted service. And substituted service, in a nutshell, means that you're basically asking the court, whether you can serve the notice to show cause or the interim order, whether you can serve it either on Facebook or on WhatsApp or on any social media platform where they are mostly active. And we have also had a case like that, and the court granted us permission to serve on WhatsApp and Facebook, and the respondent then was notified of the document that we were serving, and the court was satisfied with that service. So you can do that where you don't know where the respondent lives or you can't locate them. That's an avenue that you can take.
Then I see another question: what steps to be taken in a situation where the police are reluctant to act or enforce the protection order? So we do encounter issues with this sometimes, especially if the complainant is unrepresented, where the police is reluctant to act or enforce the protection order. Usually we would then advise, especially if it is at night, or if we're not in close proximity to the complainant, we'd advise them to go to another police station to try and enforce the protection order. Usually what you can also do is you'll get the senior police official's number, the captain's number of the police station. It should be available online. We try and escalate it to the senior police officer or the captain of that police station. Most of the times we also work with different help desks in and across the Johannesburg area. So we will ask for senior police officers' details to actually report this conduct to the senior, the captain of the police station, etc. It is something that is very frustrating and that we have encountered on some occasions, but you need to try and do in that instance is see if you can't get a senior official's contact number, and also try and report that conduct as well. But what that complainant can do is, in that instance, go to another police station and actually explain that the police station that has jurisdiction is failing to enforce this protection order and that they need assistance. And that police station would then be able to assist with the enforcement of the protection order.
Then I see the question from Temba that says, what happens if the complainant has contravened the interim protection order by communicating and visiting the respondent immediately after the first court appearance date, and yet the interim protection order is still active? I think that is a very good question, because a lot of times the complainants sometimes are the ones that actually contravene their own protection order in basically what you said, visiting or going to the respondent. Now, in this case, what's just unfortunate is that the respondent has a protection order against him or her, but not against the complainant. So you can't essentially arrest the complainant, but I think you will have good grounds for a counter application. That would be something that the respondent would have to do. Also approach the court, well, because remember now, if it's an interim protection order, it means that the matter is still ongoing. It's not final yet. So in that regard, you can bring a counter application as the respondent. And if it is final, but you find that the complainant is the one contravening the order, you can also approach the court and get a protection order against the respondent. But yes, that is what you can do. You can't rely on the protection order that is against you as the respondent to basically arrest the complainant. You will have to obtain your actual order against the complainant.
So I think some of the other questions we have actually answered. It seems like it's a bit of a repetition. I think that's
Maybe
all
people
the
have questions.
questions. Yeah, if there are any questions from the floor, please can you just raise your hand and unmute yourself, and we'll then take your question. I see we have 5 minutes left, so if there are any questions, please let us know.
I see Josina had her hand up, so if you can unmute Josina and ask your question, please.
I'm not sure if Josina's hand was up earlier on.
Yeah.
I saw it up for quite some time, so it might just be that she hasn't lowered her hand.
I see we have a question where Tasleem is just asking again, saying that I appreciate the reply. I don't think my question was answered properly. Was answered or properly understood. I meant, what happens after a respondent cannot be served? What is the court process thereafter, or what happens to the case, etc.? Is it set aside? Do they still get to show cause, etc.? I think that's what I mentioned earlier. If you say that, what happens if the respondent cannot be served? If it's in and maybe in relation to the location, you can't locate them, then in that regard, the matter will not be set aside. What you need to do then as the complainant is to approach the court and inform the court that the respondent has not been served and cannot be located, or you cannot serve on the respondent. And that's where you then ask for alternative ways to serve. You have to ask for permission from the court to maybe serve on the person alternatively, or maybe change the address if it's maybe at their workplace, or you can ask to serve on social media like WhatsApp or via SMS, or, since we do live also in a digital space, chances are you will be successful in that regard. But you have to approach the court in that regard.
Yeah, and maybe just to add on, like Malefa mentioned, there's other options, like you'd bring the application for substituted service, ask the court if you are a friend with the respondent on Facebook to serve on Facebook. We've done that in instances where we'd serve on Facebook, so serve on WhatsApp, serve on Instagram, serve on LinkedIn, whatever digital platform is available that the respondent is making use of. You can request the court to serve on those or in that manner. And then if the court has actually granted service in that manner and is satisfied that you've done possibly what you can to bring this application to the attention of the respondent, and the respondent fails to appear on the next at the court date, the court can then make a decision on whether they grant a final order or not. But essentially, the test that needs to be satisfied is that you've done what you possibly can to bring the application to the attention of the respondent. And in that instance, where the court is satisfied that you've done what you possibly can, the court can then either decide to grant the final protection order or not to do so. And that would be the same instance where the respondent is actually served and they don't come to court. It's the same instance where they would then not be given an opportunity to put their version before the court, but the court still has the power to either grant or not grant it, as long as they are satisfied that you have done what you possibly can to bring the application to the attention of the respondent.
I see they say many of the clients will say their cases are at its standstill due to the fact that the respondent cannot be located and they don't have social media whatsoever. And I guess that's just one of the difficulties that you experience in terms of, approaching the court and the whole process of applying for protection order. This is unfortunately one of the difficulties because, as we mentioned earlier, if the respondent is not aware of the protection order, it cannot be affected. And we also had a situation where we could not get a hold of the respondent at all. We still obtained the interim protection order. Then we had asked for the matter to be postponed for quite some time. Now, the benefit is if you can't get a hold of them, then the client is not being exposed to the violence, which is a great thing on that end. But if they do make a reappearance, which is now the respondent, then one can always ask, then you can try again to maybe serve on them. And then what we did is if we had not been able to serve on the respondent by the return date, we would ask for another postponement and ask that the interim order be extended. So that's a very important request also to ask the court to extend the interim protection order.
Yeah. I think we'll take one last question from Thandi, and then I think our time is up.
Thandi, you can unmute yourself.
I think we probably answered her question. So that's it from our side. Thank you so much for your time, and we hope you found this presentation quite helpful.
No.
Thank you very much, Andrisha, and thank you very much, Malifa, for the very informed presentation. We so much highly appreciate. So to all our participants, we normally share our presentations to all participants. Thank you very much. It was very informative.
Thank you all. Thank you for participating. Thank you for allowing us to participate in this whole seminar. Thank you. Bye. Great information.
Hi, everybody. I'm so sorry, ladies. I couldn't make it today. Anissa, coordinator, we've liaised via email. I was in another meeting. I'm really disappointed, but I have the recording and I thought I'll just pop in and thank you for a great session. The attendance was good, and I'm hoping that, I know that everybody who attended really benefited from it. Thank you, everybody, and have a great day.
It's a pleasure. Thank you.
Hi, everyone.
Thank you. Bye.